court appeal on the gag order that Judge Barbara Elmore put in place in the Aaron Spencer case. I have not watched, so you will get my real first time reactions to this, but this goes with, First Amendment. Like, you cannot silence people, and we cannot do things in secrecy. So I would like to see what the judges panel has to say during the hearing. We have already gone over the gag order itself. If you have not seen that, I will put a link to that video up in the eyelet, and it will also be in the description box down below if you have not listened to that or read it. So, but before we get into the hearing, I want to go into a little uh, about who Judge Elmore is, um, because I kind of want to know what type of person is doing this. Like, what is her background? Who is she that we can see? So, well, we're going to bring up her Ballotpedia, which is like basically a place you can go anywhere, even in your jurisdiction, to look at candidates who are on your ballots, judges and such, to learn a little bit about them before you go and vote. It is a pretty decent resource. So, let's bring this up. So, we have Barbara Elmore. And then let's see if what is making it bigger do? Did that help us a little bit? Okay. All right. Remember to hit that like button, subscribe so that you can stay up to date in this case. So there's a picture of Judge Elmore. She is Arkansas's 23rd Judicial Circuit Division 1. This said her term ended in 2020. Obviously, it didn't because she's still there today. So she apparently went to University of Arkansas Little Rock for her bachelor's and then also for her law degree. She was appointed the position by Governor Mike Beebe in 2007 after the Arkansas legislature created the judgeship. She was then elected to a full term in 2008, and then she was reelected on May 20th, 2014, and that term was expiring in 2020, and it sounds like when that election came around again, she was also reelected. Will she be reelected after all this? I don't know. She might be done on the bench after the shenanigans she pulled in this case. They may not trust her. Um, she won in 2014 without opposition. She received JD from University of Arkansas Little Rock, William H. Bowen School of Law. Her career was prior to being appointed to a Division I. Elmore was a circuit judge in other divisions of the 23rd Circuit. She was also the district judge of the Southern District of Lonoke County, Lonoke Division from 2005 to 2007. Previously, Elmore was both a criminal prosecuting attorney and a defense attorney working in a private practice, and she was admitted into the bar back in 1995. She is a former president of Lonoke County Bar Association. She has been she was a part of the Lions Club, Cabot's Citizen Club, Arkansas Judicial Council, Arkansas Bar Association. So that is a little bit about her. She has there's articles and everything else. So we'll see. This might be her last. Seems like this might be her last term. Or is there enough corruption people that are still going to vote her in? But that is Judge Elmore. Now let's get to the hearing. And I'm going to share my screen. It is about an hour long. It doesn't allow me to adjust the speed. So if you are watching this and it's going too slow for you, you can always adjust your speed in the video itself when watching this. I just can't do it here to make this video any shorter. But let's get started.
All persons having business before this honorable court, draw near, give attention, you shall be heard. The Constitution of the United States, State of Arkansas, and this honorable court. You may be seated.
I have the audio up as loud as I can get it. I don't have a way to boost it anymore, so my apologies on that. If anybody knows something to boost audio with things, let me know because I don't know how to do all this, but I'm doing the best we can. All right, let's go back to this.
We have cases to hand down this morning. Justice Womack, would you start?
CB 24-283, Kenneth W. Tilley, individually in the trustee of the Kenneth Tilley Family Trust versus Malvern National Bank and Stephen Moore from Garland County Circuit Court, affirmed in part, reversed and remanded in part. Justice Baker and Hudson and Highland concur in part and dissent in part. Justice Wood concurs.
Justice Webb.
CB 24-127, Jeremy Kennedy versus John Feltz, Director, Arkansas Parole Board, Dexter Payne, Michelle Gray, and Stanley Robinson from Izard County Circuit Court. Affirmed. Special Justice Barbara Halsey joins. Justice Womack dissents, and Justice Bronny was not participating. CB 24-712, Jonathan Brizendine and Melissa Brizendine versus the Department of Human Services.
Okay, so they might be talking about some cases. I will have it time-stamped when it starts on Aaron Spencer's case. This is the section they had clipped for it, so hopefully they'll get to it soon. My apologies. Like I said, this is a first watch.
Justice Highland.
Case number CR 24-563, Jason Meredith versus State of Arkansas. It's an appeal out of the Circuit Court of Saline County. It's affirmed. Special Justices Barbara Halsey and Mark Allison join. Justice Wood dissents. Justice Webb and Justice Bronny not participating.
The clerk, please read the submissions.
There are 6 appeals submitted to the court today. They are all criminal cases. The first one's our oral argument this morning. That is CR 2566, Aaron Spencer versus the State of Arkansas from Lonoke County Circuit Court. The cases submitted on the briefs in the record are CR 23401, Morgan and Weatherford versus the State from Logan Circuit. CR 24143, Dennis Hale versus the State from Sevier Circuit. CR 24157, Elizabeth Haney versus the State from Ouachita Circuit. CR 24240, Warren Goodrum versus the State from Pulaski Circuit, and CR 24353, Devin Romick versus the state from Crawford Circuit. In addition to these 6 appeals, there are 20 various other motions and petitions submitted today. More information about these appeals is available at the court's website or by contacting the clerk's office.
Thank you. Are there any motions from attorneys or parties present?
No, Your Honor. No, Your Honor.
At this time, then, we will take up the oral argument scheduled for this morning. CR 2566, Aaron Spencer versus State of Arkansas from Lonoke County Circuit Court.
That's the one we're here for.
Acknowledge the petitioner's attorney to come forward. Ms. Casanelli. And you've reserved 10 minutes for rebuttal, is that correct?
Yes, Your Honor.
You may proceed.
Thank you. May it please the court, counsel. I'm
This
Erin
is one of Aaron
Casanelli, and
Spencer's
I, along with
lawyers.
Michael Kaiser, represent Aaron Spencer, who's the petitioner before this court and the defendant in the court below. We are here today on a gag order imposed at the inception of a criminal case in the circuit court. Gag orders should be a last resort, not a first impulse in any case. And I would submit to you that's fairly settled law. The law requires a careful analysis and a balancing of important constitutional interests when imposing a gag order. The law requires further a very narrowly tailored order that is specific to the case, the interests in the case, and the interests of the public in receiving speech and the parties in providing speech. This court, federal courts, the criminal justice system does not favor justice in the dark. And that is what is happening in Lonoke County. In this particular case, this gag order is very important. This is an unusual case. I don't know how much factual information has been conveyed to this court, but it's unusual in several respects. Aaron Spencer is a father and a husband. His daughter was assaulted, sexually assaulted, severely, by a man named Michael Fossler. Michael Fossler was arrested and charged with over 40 criminal offenses relating to his behavior against Mr. Spencer's child. He was released by the Circuit Court of Lonoke County with very little restriction.
So counsel, if I can interrupt you right there, just a factual clarification. Was it the same judge who issued the gag order was the judge in that case?
Yes, sir, and thank you for that question. You caught exactly where I was going. It was the same circuit court and the same prosecutor who participated in Michael Fossler's criminal proceeding. And that's important in additional respects.
Which is
There no
insane
public record of his
that they are the
appearance
same
that
people
I
in
could
both
find
cases.
before the circuit court. There's no record of what bond the state sought, why the court imposed such a low bond, why there were no restrictions or supervision as to his conduct. And of course, that led to him taking Aaron Spencer's daughter in the middle of the night to continue to rape her.
Counsel, I have a question. We live stream our court proceedings, and this is a public hearing. So, and it's live streamed. It's also saved on our website. Is that violating the current gag order?
That is an excellent question, and also on my list of things to discuss before this court. This gag order is so overbroad that I don't know that I can answer that question precisely. My belief is that this court has.
How ridiculous would that be? Is if going to the Arkansas Supreme Court, where they live stream and record their hearings and they're posted publicly, that they could be in violation of the gag order simply by Arkansas Supreme Court's practices. That if because Arkansas Supreme Court decided to put their stuff publicly as they do in everyday life or their everyday course of business, that they could possibly have been sanctioned by Judge Elmore. That seems very unconstitutional. That's something that the Arkansas Supreme Court, they could be messing up the gag order and receiving sanctions and violating court orders in the lower court. And this judge on that panel is like, well, are we violating the gag order just by doing this? And Aaron Spencer's attorney is like, I don't know. Possibly. Then why we're here. Because should this be something that's allowed? No, nobody should hold that much power to be able to silence everybody, and just going to the Arkansas Supreme Court and them posting the hearing publicly be in violation. It's crazy.
Asked for this argument, and I cannot fulfill my duty to this court without explaining the facts and the law that apply to it. But the way the gag order is written, none of you could speak about the case from the bench here. The governor herself couldn't speak about the case if she wanted to. No public official could speak about the case.
Counsel, in preparation for the argument, all of the court has 2 law clerks on staff, 2 attorneys. Were we in violation of the order when we were discussing it with our law clerks in preparation over the last few weeks?
Arguably, you could be, because arguably you're discussing it for purposes of public dissemination. I mean, presumably you intended to come here and ask questions about it, and you intend to publish an opinion.
So doing
that
something to
pertains to it.
preserve
So
defendants'
I
rights,
suppose arguably you could be. That
they're
seems
all in violation,
outrageous.
So
technically.
let,
It's
even if you
unconstitutional.
assume that that's all true, I mean, I guess I'm confused. What's your standing to raise those arguments as to non-parties? I mean, I understand that Mr. Spencer can raise the argument as to him, and he can raise it presumptively as to counsel. But as to anybody else covered by this order, what standing do you have?
Yes, sir. There are several
In the order.
There are several things that sort of fall into
judge
that
said, "Don't
category,
mention
but as a
this
general
case,
matter,
nobody."
the overbreadth doctrine allows courts to consider First Amendment restraints that affect third parties. So I think that's discussed in the Murphy-Brown case, which cites a couple of Supreme Court cases for that point.
But for overbreadth to apply as a general matter, you have to first allege that this can be constitutionally applied to you. The reason why we conduct the overbreadth analysis is because it's constitutional as applied to you, but it's unconstitutional theoretically as applied to others. Here, your argument is it's not constitutional as applied to you, so I'm a little bit confused how we get to overbreadth.
Well, either way, I think it's unconstitutional as applied to my client, in part because it's overbroad and it encompasses both his right to speak and his right to receive speech. The First Amendment covers the communication itself on both ends, which is why all the cases
Are there cases that treat overbreadth that way? I mean, I'm not familiar with any Supreme
No,
Court
that's
cases.
a bit of a different doctrine. So think of all of the cases most of the cases that are out there involve the press, right? The press is coming forward and saying, we oppose this gag order that you have imposed that prevents all the parties from speaking. And the press is the recipient of that speech. And most often the defendant doesn't want the speech, but the press is still allowed to bring that motion. At times the parties bring the motion, but they are addressing whether they can speak and whether speech can be provided, for instance, in public records.
Then I guess my question is, if we found the gag order is unconstitutional to you, your client, is that sufficient, or are you seeking more relief and that's why you've argued overbreadth? Because normally if we said it was unconstitutional as applied to you, the analysis would stop. There's a stack of First Amendment cases that say that. The analysis stops. Would you be satisfied with that relief, or are you seeking to invalidate the entire gag order? And again, what's the standing for that?
I don't think that the court has to go that far, because I think that it's unconstitutional as to Aaron Spencer, and that would cover all of the concerns, because there's really not a part of this order that is sufficiently clear, that indicates a substantial compelling interest, that's narrowly tailored. So I think that if the court decides that the order itself does not comply with constitutional mandates, then that is sufficient to get to the end, which is that it needs to be submitted back to the circuit court for a proper analysis.
So a slightly different variation of this question than what I took some of your arguments to be framed as. Yes, they were sometimes framed in terms of overbreadth. I thought maybe you were making a facial challenge as to the gag order itself and just arguments unconstitutional in all of its applications. Am I wrong about that? Or
That's a tough question for me to answer. I think, I believe that it is facially unconstitutional, but I don't think the court has to reach that point. I think for purposes of our argument, pointing out the circuit court's disregard for the rights of the people that it encompassed in the order, and for the overbroad.
But that sounds like a facial challenge, right? That when you start talking about other people, if it's an overbreadth challenge and we decide that it's unconstitutional as to you, the analysis stops. So you've either got to say it's a facial challenge or it's not really an overbreadth challenge at that point. So which is it if you're talking about other people?
Well, what the point that I'm trying to make is I think that is important evidence of the order's overbreadth and the problem with the circuit court's lack of analysis. I think.
Okay, so we're a little bit into this, and so it might, to some, feel like this judge is against this attorney right here. And if you're used to just watching regular trials, you don't see a lot of input like this and judges asking questions. You might see them in like pretrial, like motion hearings and things like that. But when you argue in front of the Supreme Court, this is how it usually goes. You have this panel of judges, and they are going to ask questions, and they're going to go hard on both sides. And so right now, it may seem like this judge just doesn't agree with anything, and that they're just asking questions because they want answers to specific questions, and to see if the attorneys can, come up with their argument for those things. Instead of just letting them ramble and ramble and ramble, it's like, these are the questions I have for you that's going to help me make a decision in this case. And so they're more pointed, and some of them are going to seem more favorable, and then some are going to seem like they're being harsher. And it's really hard to tell in these types of hearings which way it's possibly going to go. Sometimes it can be easier, but there's going to be like light softball questions that makes it appear like, oh yeah, we agree with you. And then there's going to be some hardball questions because they are trying to overturn a judge's order and a judge's ruling. And why should they go against this judge? Because judges have a lot of discretion. But if something is unconstitutional, that somebody in the lower court is doing something like that, these higher courts have to correct that course. And so they need to be shown why is what Judge Elmore did so unconstitutional, or is it unconstitutional? Is it an unconstitutional to everybody in the entire order that's not allowed to talk about this case, or is it just unconstitutional when it comes to Aaron Spencer? So whose rights are being violated? Is everybody's rights being violated? Or is it just the defendants? Or is nobody's rights being violated and the judge has the right to do this? So just keep that in mind if you're thinking, wow, this judge seems like a butt. He's not being a butt. He wants this lawyer to answer these pointed questions, and you'll see it further on in this, and you'll see it when the state gets up and argues their case as well, I'm sure. If you've ever watched appeals oral arguments, this is just how it goes, for those of you who don't know.
That
Counsel, perhaps, what I thought I heard you say earlier was that it wasn't just that you're arguing that prohibiting the defendant's speech. It was his receiving speech as well. And is that why it, in a sense, you're arguing it's unconstitutional, the restrictions on others is because it prevents them from him receiving their speech?
Your Honor, thank you, Justice Wood. My point there was just that the First Amendment protections are both as to recipient and speaker. In this instance, our position is that Aaron Spencer, the attorneys, the people that represent him, his family, any interested party should both be able to speak and have access to the information necessary to speak. So, for instance, closing all court records. And by the way, there were no court records made public. So even the affidavit of arrest or the charging document aren't public. But he has a right to access those records and share them with other people. That is speech.
That seems to be slicing it, I mean, putting too much emphasis on one point. I mean, courts seal records all the time for various reasons. Now, maybe you don't think there's sufficient justification here. There, as far as I can tell, there really are no fact findings here. So maybe it's not warranted here, but there's not some abstract right. I mean, I don't think you can identify a case, can you, where the courts have recognized an abstract right to access information that says courts can't seal their records?
I'm sorry, Your Honor. I believe that the right to a public trial includes the right of public access to court records.
Does it include the right to release evidence that you obtain in discovery then, in your view?
No, I think discovery is treated differently. Discovery is regulated under court rules. I'm, as an attorney, prevented from disseminating discovery material. There's no need for a gag order in that respect. The court rules cover that. So I think the case law also suggests that discovery, the United States Supreme Court has addressed that discovery is a separate and protected class. I'm dealing only with the public record aspect, and I agree with you that absolutely the court can seal records after the appropriate analysis has been undertaken that shows a need to do so. In this instance, we have sealed every public record. In fact, I noticed that since we filed the final brief in this case, the circuit court clerk has added some notations to the electronic docket online. But while we were doing briefing, you couldn't even see the title of documents that were filed. There's no record of my client's entry of a not guilty plea. The public was prevented.
Read correctly at some point that the arraignment was actually sealed?
The arraignment, the court would not allow community members in the arraignment. I raised an objection. It was not well taken. And so they were not allowed in the courtroom.
So no members of the public, no members of the press allowed at the arraignment?
I can't swear to that because my back was to them, but I watched the bailiff and
Yep, you heard that right, Judge. The arraignment was done in secret. Nobody was to know about the arraignment. It was not open to the public. And so while the judge may have the right to say, no, I'm not going to live stream this, you cannot close the courtrooms. The public has a right to know what the hell is going on in their community and what the people in power are doing. This is not a secret society. This is not how things are done. It is abhorrent. That is shady business.
heard him tell numerous members of the public that the court had ordered that only two members of the defendant's family and I believe 2 members of the victim's family would be permitted in. Whether or not he ultimately let somebody slide in, I cannot attest to that, but he turned away a line of people, and it wasn't 100 people, it was about 8 or 10, and he turned them all away.
So we haven't even, are you raising a right to public trial? Because we haven't, extended that beyond we haven't extended that to arraignment and further.
No, Your Honor, I'm not, but it is an important consideration here because I may not, Aaron Spencer may not have taken so much issue with this gag order if it didn't seem like this entire proceeding and the entire proceeding of Michael Fossler were being conducted in secret. And the public, members of Lonoke County, have a great interest in knowing how this happened and knowing why its public officials are making the decisions that they are.
Ms. Casanelli, you said something a minute ago that made me think that the remedy you're seeking here is for this court to remand or send this back to Lonoke County Circuit Court to have a hearing. Is that what you're asking for?
I'm asking this court to vacate the gag order and to provide the court and all courts in Arkansas with some kind of analysis, some kind of careful balancing, some direction, and order the circuit court and all circuit courts to conduct such analysis before they impose a gag order to ensure that it is appropriately narrowly tailored only as is necessary to prevent substantial prejudice. That's what I'm asking for. And in this instance, the circuit court undertook no analysis, took no evidence. So there is nothing on which a tailored gag order could be created and imposed.
So the standard you just articulated, in which case does that come from? I mean, I know that the cases say various things at various times. It's a little bit unclear what the U.S. Supreme Court has told us the standard is here. Where are you getting your standard from? What is the closest match? And is it the same standard applied to everybody that this gag order applies to, or is it just the standard that applies to you and your client?
So I would submit to you that the standard doesn't matter. Under any of the standards that have been laid forth by the Supreme Court, this gag order fails. I could talk all day long about whether Gentile sets a standard or Nebraska Press should be used, but I don't think my evaluation is that there is not a rigid test. I think the Supreme Court has said repeatedly, like the clear and present danger is not a formula. It is an indication of the careful balancing that should be done to ensure that a gag order is addressed only to a substantial and compelling public
But
interest.
the balancing language, where does that come from? I'm not familiar with a case that says balance.
Nearly every U.S. Supreme Court case talks about the weighing or the balancing.
But does it actually apply a balancing test as one would traditionally think of it? Or does it just say we balance in formulating the standard, we balance the interest? Or is it a pure balancing test?
It is not a pure balancing test. The court has been clear that it's unique to every case, but that it has to have the hallmarks of applying the heavy presumption of unconstitutionality as to a prior restraint, such as a gag order.
And in response to Justice Hudson's question, you were asked, what are you seeking here? Are you just seeking sending it back for hearing? And you said you'd like guidance, but what I just heard from you is an amorphous test that doesn't really provide that. I mean,
unfortunately, the United States Supreme Court hasn't addressed this situation because most often it's a defendant's assertion of a right to a fair trial that was not honored because of change of venue, or it's a press case. So I think we're looking to this court to help us in the state, to help us combine those cases and come up with what is the proper direction. But I do not mean to insinuate or indicate at all that there is a rigid balancing, because I think that the constitutional rights at issue don't allow for that. It's going
do I
to be
take
different.
from your answer then that you think the standard varies depending on whether the state has asked for it versus you've asked for it?
No, I do not think the standard varies. I think that the circumstances of the case are necessarily going to make, for instance, the state's compelling interest in a fair trial is going to have a different weight under the circumstances of each different case, as will the need to narrowly tailor the order. It necessarily.
So the judge here is trying to say, okay, you brought this appeal to us about this gag order. You want the gag order like vacated. So they're trying to say, well, do you want us to just have the circuit court just reissue this and have a hearing on it and redo this? Do you want us to completely tell the court there that this is what needs to happen? What do you, Aaron Spencer's attorney, want us to do about it if we feel that the law is actually on your side and not on Judge Elmore's side? Tell us what you are wanting. What do you want us to do? What do you think should be done? Give us some guidance so that we kind of know what you're seeking and if that's even able to be done here. They want her to just tell him, like, let's not beat around the bush. Why are you here? What do you want us to do? Why do you think that we should be able to do that in this case and change things?
Necessarily has to be specific to the case, but we could use some real guidance as to what courts have to do to evaluate those issues.
Your time has expired. You can continue into your rebuttal, or
Thank you.
thank you. The attorney for respondent?
So now the state is going to get up and do their case. So we'll get to see the difference and how they treat this lawyer as opposed to Aaron Spencer's lawyer and hear both arguments.
Thank you. Madam Chief Justice, and may it please the court, I'm Assistant Attorney General Joseph Carl Lupke here today on behalf of the respondent, the state of Arkansas. The circuit court's gag order in this case was an appropriate exercise of its discretion that helps achieve its primary constitutional duty to ensure a fair trial occurs in this case and that justice is done. Reviewing this order and Spencer's claims under the intermediate scrutiny standard set out in Gentile versus State Bar of Nevada.
Counselor, what would be the harm in sending this back to circuit court for an evidentiary hearing?
I think the harm is that there is sufficient evidence in the record to support the order here. It is undisputed. They didn't dispute it below. They haven't disputed it here, that there was sufficient media attention, expansive media attention, that supports the idea that there is a substantial likelihood of material prejudice based on statements from trial participants. And then the other thing you have is the statement that was attached to the state's order, which represented an effort on the part of the defendants and his attorneys to try this case in the press. And when you have a clear attempt to try the case in the court of public opinion rather than the courtroom, then it is appropriate to prevent.
Wasn't there just one statement here? I mean, you only attached, I think, one statement from defense counsel. I mean, that seems like a little bit of a jump to say there's been one statement that the defendant says was in response to something that the prosecutor had said cryptically. Like, that seems like a bit of a jump, doesn't it?
There is only the one statement in the record. That's correct, Justice Bronny. But I think when you read that statement, you can see the intent behind it. And the fact that it was in response, or may have been in response to statements made from the state, those statements aren't in the record. The fact that the state may or may not have made statements only further supports the need for the gag order. The fact that both sides are talking means that a gag order is appropriate. And when you read the substance of the statement, it contains a style of argument that wouldn't be allowed in court. It has evidence as to the character of the accused and the character of the victim that may or may not be admissible. And so this court, the circuit court, needed to ensure that the case is decided based on the evidence that comes from the witness stand, and that's what the gag order does.
But you jump from one point to the other. I guess where I'm confused is I'm not aware of a case that says you have a right to the state or anybody else, a right to a trial without any publicity, which almost seems like what happened here. The circuit court decided there should not be any publicity. Instead, your right is to an impartial jury,
That's
right?
correct.
And why wouldn't things like voir dire be sufficient for dealing with that? I didn't see any findings to that effect here.
One, I think because voir dire was raised in the defendant's briefing below, it's implicit that it was rejected by the circuit court. I think you can find an implicit finding there. And I think what the Shepard versus Maxwell case says, and what Gentile itself says, is that when we're looking at ensuring a fair trial, the court has to act prospectively to prevent prejudice before it happens.
Counselor, let me ask you something. I think you just said that it was included in the defendant's objection below. Are you talking about the 19-page objection that they filed to the request for the gag order?
Yeah, I think they mentioned.
So how quick, and you said that because it was included, it's fair to assume that the circuit court considered that and rejected that. Is that a fair assessment of your argument on that point?
I think you can assume that.
Okay, so let me ask you, how quickly do you read?
As quickly as I can, Your
So
Honor.
if you had to guess, how many pages per minute do you think you read?
If I'm reading carefully, a page a minute, probably.
So if the defendant in this case filed a 19-page objection, and 6 minutes after that was uploaded to the system, after the clerk accepted it and uploaded it to the system, the circuit court, 6 minutes, the circuit court filed the answer with multiple handwritten interlineations in the order, excuse me. Do you think that we can fairly assume that in those 6 minutes, from the time the 19-page objection went live until the time the circuit court filed her order, that she read, considered, and gave due weight to the defendant's objection in this case?
Excellent point, Judge. I do not know this judge's name. 6 minutes from the time that Aaron Spencer's defense team uploaded their request, not to have this gag order, 19 pages. And she was able to read, analyze, and consider all arguments on that page, all 19 of those pages, and make her notations and put an order in, all in 6 minutes. Do we really think that this judge actually read every single page, actually carefully analyzed and considered all of the arguments placed before her by Aaron Spencer's defense team, and then made her order? No. There's no way. Even a speed reader could probably not do that. This to me shows that Judge Elmore could care less what anybody has to say about her orders, because her orders are her orders. And it doesn't matter what type of argument you bring. She is the one in charge. Do not question her. And the judge asked this question because the state's appellate attorney arguing right now was like, well, we believe that you can take and insinuate basically that the judge did take that stuff into consideration when she made the order. And the judge is like, but can we? Can we take that into can we insinuate that she actually carefully considered these things and did that in 6 minutes? Could you do all that in 6 minutes, sir? Love the question. But as you can see, they're going hard on him, just like they were asking hard-hitting questions to Aaron Spencer's lawyer as well.
First of all, I would reject the premise of the question. I don't think there's any evidence. They have alleged 6 minutes in their briefing, but all we have in the limited record before this court is the file stamps. And the file stamps of the order and the file stamp of the response indicate 2 separate days. That's all this court has to consider. And I don't know that we can know for sure whether or not the court had access to the response before it was pushed through by the clerk. I can't speak to that. I know the response was before the court and it had the opportunity to consider it, so I think we can find an implicit
Counsel,
finding here.
let me ask you another question. When you're talking about discretion, and I think that's what Justice Womack's getting to, you said the court exercised discretion. This order is substantially the same as an order that we vacated in 2020 in the Arkansas Democrat Gazette case when they brought a writ of cert to this court.
So they've already dealt with this scenario back in 2020. They're like, we've dealt with vacating orders like this. So why shouldn't we vacate this order? Because we've already shown that this is not going to hold up. Did Judge Elmore know about that? Does she give a flying flip that this was found to be not okay back in 2020? No, she could care less. It's Elmore's courtroom, and she will do as she pleases, in my opinion. Y'all may draw a different opinion. That's why I want y'all to listen to both lawyers argue to the Supreme Court. Go back and look at the gag orders. Go back and look at the motion to the appeal court that they gave, and come up with your own conclusion whether you think that what this Judge Elmore did was unconstitutional, and was the appeal court of Arizona or Arkansas Supreme Court valid in vacating this gag order on everybody and anybody to mention this case.
So I guess how much discretion really was there? And it wasn't a carefully crafted order, because it's obviously looks like a standard order that's being passed around either by prosecutors or by judges at the circuit court level. And so that's my question, is why would we treat it any different than the case we vacated in 2020?
I think you're dealing with who's making the petitioner here. The petition is the defendant and not the press, and we treat press cases differently than those of the defendant. And I think when you're looking at the order here and whether it's narrowly tailored,
Does the defendant have more rights than the press? I would say that they do in this regard. Press does have their own rights, but I believe that in a criminal case, the defendant has way more rights than the press. So if it wasn't okay in a press case, I don't think it should be okay as and when the defendant asked. It should be more scrutinized when it's the defendant bringing it and not the press, because the press has some other interest, you know. The defendant, I think, needs to be examined closer because of their fairness and constitutional rights.
I would compare
But
the
we
categories.
vacated it completely. We didn't just vacate it as to the press. We completely vacated it. And it had the same limits as to the defendant, the family, the friends.
Does this lawyer
the
seem prepared
officers.
to answer these
It's exact-
questions?
I mean, same language.
I'm not aware of that case, so I can't speak to that, and I apologize for that. But what I would ask this court to do is compare the restrictions here with the restrictions that were present in the rule in Gentile, and they are very similar. The rule in Gentile is found in the appendix to one of the opinions, and that was found to be narrowly tailored for First Amendment purposes. And so I think that this order
For purposes of the defendant's counsel, perhaps, but one, it wasn't a prior restraint, right, in Gentile, so that's different. And that was a case about defendant's counsel.
Prior
Here, I think
restraint
you can
is
see,
really hard.
correct, that this order goes beyond defendant's counsel and applies to the defendant. Why doesn't that make a difference? Where do you get from Gentile that standard applies to others?
I think two things in response to that, Your Honor. In terms of why it would apply to the defendant and other parties, Gentile, while it did specifically address lawyers, some of its language said, because lawyers have special access to information through discovery, client communications, extrajudicial statements, their statements are likely to be received as authoritative. All the parties here that are restrained are in the same boat. A statement from the defendant is likely to be received as authoritative because he knows what happened. And so the same justification that applies to lawyers would apply to him. I would also say that while Gentile dealt with a subsequent punishment, the bar rule at issue there was a prior restraint on the attorney's speech. It was a rule that existed that restrained the entire attorney's speech. He was then subsequently punished. But I think it can be viewed as a prior restraint.
So that one, you could make the argument in Gentile that was people directly connected. There is language to that effect, but here we have an order that applies to any public official now holding office.
Yeah, and my first response to that, Your Honor, would be that those claims aren't in front of this court. The defendant doesn't have standing to raise them. And then secondly, Well, I say that, public officials that may be broad and probably could be reformed. The idea that some public officials, like the sheriff who investigated the case, court clerk, other people who might have knowledge who were specifically directed, I think would fall into the same category as attorneys, defendants.
So answer the question that was raised earlier by one of the other justices. We're public officials. We all have clerks and administrative assistants. This morning, I sat in my office and discussed this case with 3 people that work for me. And we talked about the evidence and we talked about the issues involved. Did I violate Judge Elmore's gag order?
No.
Why not?
Your
Because it says
discussion,
any public official now holding office.
because the restraints in the gag order are for public dissemination. Your discussions in your chamber are private. And in fact, they're, exempted from FOIA, that you have a right to in crafting opinions.
Facebook post by the lieutenant governor. Covered, not covered by this gag order.
Arguably covered by this gag order, and I think the state would concede that that's probably inappropriate. She doesn't have any special knowledge.
You
of
say
this case.
inappropriate, do you mean unconstitutional?
I don't know that it's necessarily unconstitutional, but I don't think it was, I don't think that claim is before this court.
So your
And-
boss is the attorney general. Every legislative session, the attorney general has a package of bills. Let's say he wants to go to the legislature and ask for a bill that addresses this very situation. He wants to add an affirmative defense to the statute in this type of scenario and has to give the reason why he wants to do that. So he lays out the facts of this case.
I mean, we're party litigants to this case. I'm responding. and
Okay, so
representing
let's say
this
it's the
court.
governor's package.
I think the
Did the governor violate Judge Elmore's gag order in doing that?
I think the term public officials is probably, if the public officials claim were before this court, the general proposition of public officials is probably too broad and should be reformed.
So what about family?
I
Whose
think-
family? Is that spouse and kids? Is that the 4th cousin you met once at a family reunion 30 years ago? That's talking about it at the coffee shop?
And I think that is part of the problem with the general term family, and it's the limits of the English language that perhaps that should have, that
Very
was not something the state
vague and
requested, that's something the
ambiguous.
circuit court did on its own.
Needs to
I
be
do
more
think it
narrowly
is
tailored.
appropriate to restrain certain family members for the reasons I said. Spencer can't filter his speech through his
Ridiculous.
wife or his mother or people that they would see as authoritative. But I
So
think it
are
would
you
be
reading that
appropriate.
in, then are you reading in the provision that talks about release, to Justice Womack's question, release any purported extrajudicial statement? Are you reading that as a limitation into the family language? Or I guess I'm a little confused as to the position.
I'm sorry, could you repeat that?
So
I
the
apologize.
first here is basically you can't launder the statement provision. Any purported extrajudicial statement of the defendant. Are you reading that limitation into the family provision, or? is
I
it
think the
broader?
order says that the family is a restrained party and that is a restrained speech, so I think that would apply. I think that's a fair reading of the
So
order.
counsel, if defendant planned to call his daughter to testify, he couldn't publicly announce that, correct?
No, under the terms of the gag order, the identity of witnesses are protected. I
But-
think-
Then why is that necessary if you can publicly say the arresting, investigating officers and agencies are public and they're going to be necessarily witnesses? So why can the defendant not release his witnesses, but obviously the state can publicly name some of their witnesses?
I think that, first, I think that the defendant's daughter could be a witness either for the state or for the defendant, same as the investigating officers could be witnesses for either. And I just think that the terms of the order says that you're allowed to identify the arresting officers, but you're not allowed to release witness lists, and that's to try to ensure a fair trial by preventing witness.
A fair trial for who?
A fair trial for the public and a fair trial for Mr. Spencer. It's a fair trial for all parties involved and for the people of this state.
Can I ask about the overbreath thing? Because I'm not sure that I got a clear answer from opposing counsel about whether they're raising an overbreath challenge, but it's certainly in their brief.
A fair trial for who, you might ask? Because is it so that the state can have a fair trial? Or is it so that Aaron Spencer can have a fair trial? Notice in his answer, he did not say the state. He said other forms. We're like, oh, the public. No. The Constitution states that the defendant has a right to a fair trial. So who needs the fair trial here? A fair trial should mean everybody, but specifically the defendant has a right to a fair trial. And he didn't really answer that fully to me. Let me know what y'all think.
What is your view of how we would conduct that inquiry? Because normally you have a statute, it's very clear, there's one standard that would apply across the board. It might be unconstitutional, or it might be constitutional as to a particular person before the court, unconstitutional as to others. Here, assume for a second with me that the court has set different standards for different people, or certainly different articulations of the standard for different people. So what do I do on the front end to determine whether or not there's substantial overbreadth? Do I have to go through every group in the order and apply a different standard and say, well, it's okay here, it's not okay there? So I add them all up and somehow it's substantially overbroad? Or how do I do that in the state's view?
I'm not sure I can answer that question, and I think your question demonstrates why an overbreadth challenge isn't appropriate here and wasn't raised here. They're raising separate challenges as it is to his speech, as it is to the other speech. They're raising a bunch of different as-applied challenges. They don't have standing to assert it on behalf of those other parties, and that's the problem. And I think that there is a possibility that different standards could apply to different parties, which wouldn't lend itself to an overbreadth challenge.
And then
the general public, sorry.
On that standard, then, I guess, what is your view of what Gentile says and what Nebraska Press says, and what is the difference between those two standards?
Nebraska Press is dealing, they're dealing, well,
They deal with different people, I'll give you that. But other than that, what is the difference in the articulation of the standard?
I think not only do they deal with different people, they deal with different First Amendment rights. One is dealing with free press and one is dealing with free speech. And those are different delineated rights in the Constitution. I think that open press, they talk about there being open discussion in this case in the public. We view that with much greater scrutiny in the law. Whereas the trial participants, what Gentile has said, what Shepard has said, and what Nebraska Press has said, are viewed under a much lesser standard because it gives the court room to balance fair trial versus those First Amendment rights.
So why does the different standard matter here? Because as I understood your articulation of the interest here, I think your view would be that you survive strict scrutiny. So like, what is the relevant difference in the standards here? Because you started by saying this is intermediate scrutiny. So you obviously care about the standard. I guess I'm trying to figure out why does that matter here then?
Well, it matters here because not only are we trying to ensure a just result in this case, but we're setting the standard going forward and for future cases. That's what this.
Yeah, this does not need to be something that happens in future cases. And if this is the standard that wants to be set by judges and prosecutors where you live, it needs to be brought to the public's attention because no, this is not something that we should have in the future. This is not a standard that needs to be set. That just everybody hush your mouth about everything so that people don't know what we're doing and we can just conduct business without anybody questioning what we're doing. Or if they do want to question it, they're not allowed to. And yeah, there is a difference in freedom of press and freedom of speech. Speech is number one. Why was that the First Amendment? Is it because it's more important than all the others? That our right to speak against the government and the people in charge? The fact that this lawyer is up here saying this stuff is crazy to me. But he doesn't seem very prepared. He has a lot of, well, I don't know. I'm not sure. And maybe it's because his job is hard and somebody's got to argue this. And he's doing the best he can with what he's got. It's just, to me, not great.
Court does. And I think it matters specifically where intermediate scrutiny versus strict scrutiny matters in this case is when it comes to what narrowly tailored means, and specifically the consideration of least restrictive means. Under intermediate scrutiny, this court does not have to, or the circuit court did not have to choose the least restrictive means of choosing its goal.
That's generally true, but doesn't some of the language in Gentile indicate that maybe this is like intermediate scrutiny with a bite almost?
No, I didn't read it that way at all, Your Honor. I think the language specifically said that the court doesn't have to rely on things like voir dire and a change of venue because those will come after the damage is done. We don't know and cannot know, that as Nebraska Press, the known and unknowable, whether or not they will be sufficient to do the job. And given the primary constitutional duty of the court is to ensure a fair trial, it's important that they act
So
prospectively.
your primary interest then is in avoiding tainting the jury pool? That's the state's interest here, or is there another interest?
Yeah, well, I think it's in ensuring a fair trial, which involves tainting the jury pool and protecting the witnesses from harassment. I think there's twofold. I think if you read the restriction in the order about the identity of witnesses, that would go towards protecting witnesses.
So what about then the restrictions on making statements about a witness's testimony after the witness has already testified? What purpose does that possibly serve with respect to either the jury pool or intimidating?
Yeah, that makes no sense. You can't even say anything about a witness after they testify? What? So you can't even discuss the case after it's over. And after that person has been on the stand, there's nothing to worry about. They've testified. People should know, the public should know who that witness was that got on the stand, because the public should be able to see, whether it's you have to be in person or live streamed. But you're not even allowed to say, "Oh, did you hear what such and such said on the stand?" Like, the news definitely could not write something about it. Um, if you saw on, like, Karen Reed, where they would be like, "Oh, what did you think about, um, Buchanan's testimony on the stand?" And she was like, "Bleh, blah, 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 blah." That would not be allowed in the Spencer case. Nobody would be able to ask him what he thought about the witnesses that day. And the attorneys, okay, they might not be able to talk, which was the thing in the Karen Reed case. Is Karen Reed could still say things, the attorneys couldn't. It was different. But once a trial is done or a witness is done, you're not worried about fairness in a trial or tainting a jury. One, the jury shouldn't even be watching anything. So how is that tainting it once they've already testified and they've heard their testimony in court?
Witnesses.
Fair trial, fair
I think
trial.
it depends upon whether those statements are made in a pretrial hearing or in a trial. I could see and concede that when the jury has already been seated, that there wouldn't be reasons to restrict statements anymore to the press as long as the jury is sufficiently sequestered or sufficiently instructed not to
Counsel,
read press
and
accounts.
it feels as if the discussions that you're having with my colleague are having well-reasoned discussions about where this perhaps could have been limited more, tailored more, and that would have been the benefit of having a hearing in front of the trial court, where the trial court could have had these discussions about what really the harms were out there, what you were trying to prevent, and that would have happened rather than sort of whether it happened in a day or 6 minutes, a quick form response.
Yeah. Even it's not great when you are saying Well, I guess I can say that, yeah, if it was after the jury was seated and it was at the actual trial, that, yeah, maybe that shouldn't be restricted. So you're conceding that maybe this gag order is harsher than it needs to be or should be. And when you're making concessions in your arguments to the Arkansas Supreme Court, that's not a winning argument, because you're basically agreeing that some of this seems a little much. And then maybe the judge, instead of just taking 6 minutes or a day or whatever they want to argue, maybe she should have had a hearing instead of just and listening to people and discussing this instead of just ruling on it within a short amount of time and not taking anything into consideration.
I think the circuit court had all the information it needed in front of it to craft the order that it did, and I think that that order is narrowly tailored. It specifically targets public dissemination of the
It's
evidence.
not
in
narrowly
this
tailored.
case,
You've
and
said it
just that,
isn't.
And that's to prevent
And
an
the fatal
insurance.
flaw with that is that we vacated a virtually identical order in 2020.
And I think that Gentile would say that
Well, it
this,
doesn't really matter, does it? I mean, that's US. We're saying an Arkansas case.
I think when we're applying the First Amendment, what the United States Supreme Court says matters.
They are telling you, stop talking about Gentile. We are done discussing Gentile, sir. You have made your points about Gentile. And I get that you think that the United States Supreme Court Gentile is going to have more precedent over something in Arkansas, which is the 2020. And it sounds like Gentile is maybe a little older than 2020. So this 2020 case is more current, maybe. But that is something to consider, is when maybe something in the US, and maybe he's interpreting it wrong, the US Supreme Court versus a lower just state Supreme Court, if those are not equal, how do we remedy it? Which one is right and which one is wrong? Do you have to go with the US version versus the state version? Does one supersede the other, or is that still judge's discretion?
Well, I would disagree when they've raised an Arkansas constitutional right here.
And I don't know that
We
this,
can give more protections, correct?
we can give more protections. They did not develop an Arkansas constitutional argument. I don't think, while they did cite it, they did not develop it. They
It's hard to
purely
do
relied.
without a hearing, isn't it?
I
develop
think they
that
could have
argument.
developed it in their briefing. They had a full briefing schedule. This court requested additional briefing. I
But would it
just-
matter if that prior order from this court was a syllabus entry instead of a reasoned opinion? Does it make a
I think
difference?
it does make a difference, because I think the important thing today, and what I would say in closing, is we want to adopt a good standard moving forward. It's important to ensure that justice isn't done in this case, but this court's opinions matter going forward. And so I would ask this court to adopt the Gentile standard, because it gives the court room.
Counselor, I know you said you were closing, but I have a question for you. On the last page of the order, right above the judge's signature, it says the entire case is now sealed. What does that mean?
It means that the public docket and the docket entries are no longer public. That's what I took it to mean.
That's what you took it to mean? Do we know what that means? Does that mean that we're not going to let the public into the various hearings and portions of the trial that happen going forward? What, do we have any extrapolation somewhere else in another document from the judge to kind of expound on, what she meant when she said the case is now sealed, the entire case is now sealed?
No, the only thing I'm aware of is the order before this court. And I think when we talk about sealing, I took that to mean sealing of the record. The defendant has a right to a fair public trial, and I have no reason to believe that that's not going to happen. I'm out of time. I would ask this court to deny the petition for writ of certiorari.
He has a right to a public hearing, a public trial. But the record is sealed and public is not allowed to say anything. Anybody involved in the case is not allowed to say anything. How is it open to the public? How are Aaron Spencer's rights not being trampled by this order? When it's like, no, nobody's allowed to see this. And it's not just like medical information that should be maybe shielded from the public and addresses and such as that. It's just random information like these motions that we've been going over. Those were all sealed, that the public didn't need to see any of that stuff. It's weird. Why can't the public see that? Why can't the public go sit in on these hearings? Why is the judge closing everything to a public when the defendant has a constitutional right to a public trial and a First Amendment right to speak? And it's really hard to police future speech because you don't know what future speech is going to be. So you're just like, well, I'm just stopping anything before anybody says anything. You can't do that because you don't know whether future speech is appropriate or not appropriate, or what they're going to do and what they're not going to do, and who's going to do it. But I think this lawyer was very unprepared, in my opinion. But you saw that they went hard on him just like they did the other lady.
Counselor, as it applies to the other party, the non-parties and the non-participants, so essentially the family members and let me make sure I get the precise language, any public official now holding office, as it applies to them, by having a gag order on them, is there any prejudicial impact on your client's rights to a fair trial or your client's constitutional rights otherwise? And if so, what is that prejudicial impact?
I would say there is a prejudicial impact. Each case that I believe in state court and in federal court that's evaluated gag orders in a similar way has addressed the scope of coverage as to third parties or groups of covered third parties. I should have made that more clear earlier, whether or not it was specific as to a very precise prejudicial effect on the defendant. However, to answer your question, I do believe there's a prejudicial effect. I think my client has a right for the public to be aware of what's going on in his case, for the public to be able to access records so that the public can make its own assessments of how it feels about its public officials and about how its criminal justice system is being operated. He is a member of the public. While he's also a criminal defendant, he is a citizen of Lonoke County, and so is his family, and so are his children. And so I think it does impact him and prejudice him, both as a citizen and as a criminal defendant. And I think every case that's analyzed this has, without real discussion, evaluated the scope as it applies to other people, as well as the scope of its application to different types of speech and other matters. So I think that that's a proper consideration. And it also, as I said before, contributes to the court's finding that the order is not narrowly tailored.
The cases that you're referring to that do that, they generally do that either because it's a press case or because it's an overbreath. So take Murphy Brown, for instance. Judge Wilkinson's opinion basically just says, we're applying overbreath analysis, never does sort of a preliminary determination of how that would work. So the same question that I asked the state, how do I conduct that analysis? Do I have to do some different test application? Assume with me for a second that I disagreed that strict scrutiny automatically applies to all of it. If I have to do that, how do I do that analysis, sort of the preliminary front-end analysis? Or wouldn't it have been easier to frame it as a facial challenge?
I think you can tell that I think that's a tough question. I think that there are different standards that apply, and unfortunately here none was applied. So any standard would be better than no standard, but I think the court does have to consider what burden must be met to prevent non-parties from speaking. I don't disagree with the state that trial participants can be restrained in ways that are more substantial than third parties, people who are not within the proceeding. I can't legitimately dispute that. But the cases, Nebraska Press, Shepherd, they don't articulate for lower courts how to do that. No Supreme Court case does, which is why we're having this discussion and why there's not a defined answer to it. But I think the circuit court has a duty to take care.
Just as a side note here, I think the jury is going to absolutely love Miss Casanelli. I think she's very likable. She seems very empathetic and caring and is going to be great for things like sensitive topics. I really like her demeanor and how she comes off, and I think the jury in the Aaron Spencer case is going to like Miss Casanelli.
To address those categories of persons in specific ways, because those rights are different and they are to be evaluated differently. I want to be sure to state to the court, there is no case that applies intermediate scrutiny to gag orders to this circumstance. There just isn't. There's no case that dispenses with the least restrictive means analysis. Gentile does not do that. In that case, it was a subsequent punishment at issue, not a prior restraint. That cannot be reasonably disputed. The Supreme Court has told us that those things are viewed differently and prior restraints are
It says that, but when have they ever actually indicated how the standard is different? I mean, I recognize you're entirely right. The court has said prior restraints are treated differently. Tradition in this country, we treat them differently. But when it comes to actually analyzing them, can you point to the delta in the way that the court has treated them differently?
Yes, I think the court historically has consistently held that prior restraints are what they call freezing speech as opposed to chilling it. Because when you speak in the face of a rule that tells you of an ethical rule, you are aware of the danger in doing so. It's very different.
I agree with you in those general terms, the court has said that, but where has it applied a different standard?
I don't know that that's specifically come before any court. I mean, I cannot think of a case where that has been specifically addressed. In my mind, that is something that is stated repeatedly. The evaluations of rules, like the ethical rule in Gentile, have been evaluated slightly differently. I would say this as it pertains to Gentile in this analysis, that because it was a regulatory rule, the court was looking at the systemic issues. So the court was looking, they didn't dispense with the least restrictive means. They didn't have a case to apply that analysis to. So in that instance, they're looking at a rule. Is this necessary in a profession that we as a state license? Can we impose this ethical responsibility? And how does that rule affect sort of the systemic costs that may be associated with it? In a case in a trial court, I mean, we don't hear circuit courts say, well, you know what, we're not going to do extensive voir dire because it's too expensive. You know, we're not going to change venue, even though maybe a defendant's entitled to it, because it would just be too much of a cost on the system. I mean, Gentile is obviously dealing with the overall systemic assessment, but within the First Amendment analysis.
Well, counsel, I think what the state was saying is that they thought that perhaps some of what you said in the statement, you could not have said in court. Would you agree with that?
I'm sorry, I could not have said.
You could not have said in the court. You could have not made some of those statements.
Well, I have sort of agree and disagree.
Okay. Well, and so I guess following that is that once you did that, was there a legitimate concern by the court that maybe you were going to keep going further, and then that justified the court issuing some sort of gag order, if maybe not this far, against at least counsel?
I think the court, and I think the Trump court talks about this in that opinion, that context is important, and that has been completely ignored by the state in its briefing before this court. That statement was made before arraignment, before there was any proceeding. It is a criticism of a public official. It doesn't include any information that is prejudicial or would be inadmissible. The character of my client will be at issue because he is of outstanding character, and there's nothing that's going to impact that. Michael Fossler's rapes of Mr. Spencer's child are public record. It is a part of this case. And
The thing is it's not public record anymore. You can't look at those filings. They have Fossler's case sealed. And that would be an important reason, if you want to learn about Fossler, to watch the Aaron Spencer case and pay attention to it, because that seems like it's the only way that we're going to learn about Fossler, because a lot of his stuff is scrubbed from the internet. People are protecting Michael Fossler. This PDF file. And it's deplorable.
that statement is geared very specifically towards the prosecutor's decision to charge him after months of us cooperating and after knowing the circumstances that led us to that point. The very person who was responsible for Michael Fossler's case. So
was there a potential of suggesting jury nullification?
I do not believe so, because I think in a justification context that the jury has to assess what a reasonable person in Aaron Spencer's shoes would have done. There really wasn't a golden rule type argument, definitely not in the written statement. I want the court to know that the one comment that I made on camera at arraignment, which is also when a prosecutor made a comment on camera, what's recounted in the motion is a mash. I made brief statements, but they were related to the circuit courts having iced the community out of the proceeding. So if you don't take them in context, you may think that I'm talking about the jury as the community, but I'm actually, in full context, was talking about the community's involvement and support of him in that proceeding and being told to go home. So I think if the court had taken evidence, then we could have fleshed all of this out. My practice is not to try my cases in the press, and I would have probably agreed to some restrictions as necessary, depending on what they were. But the court didn't evaluate any of those things. And of course, the court didn't find out what I was speaking in response to. But I submit to you that there's really nothing in that written statement
Judge Elmore
that
doesn't care what
should
you
be
were
even
speaking in
prejudicial.
response to.
Even under the
Doesn't
current
care.
gag order, his occupation, his family history, all of that is apparently okay to speak about. Public records are okay to speak about, and those are based on public records. So, I mean, just because the prosecutor doesn't like it, that is not a reason, that's not a justification for a gag order.
So if we construed this order narrowly, I realize it might be somewhat difficult to do, and just treated it as a poorly written order and construed it as most of the provisions have to do, I mean, there's the one about extrajudicial statements of the defendant, but otherwise, for the most part, what we're talking about are public dissemination or public comments about evidence, prospective witnesses, testimony, etc. If that was construed narrowly to be limited to statements about that are aimed at basically tainting the jury pool, releasing evidence, commenting on evidence, that kind of thing, does that give you the relief you actually are seeking, or is that not enough? And would that pass? I mean, the other question is, would that pass as relevant test?
It's difficult to answer that in the abstract. This order says things like possible existence of evidence. Like, I don't know what the possible existence of evidence is. You know, if we could define those contours better, then perhaps so. But, you know, some things that are potential evidence or possible evidence should be fair game for the public to learn about too. So I think we should be narrowing this to prejudicial evidence, not anything that possibly could ever be evidence. And not all of this order addresses even public dissemination. And I'm sort of unclear even what that term encompasses. You know, social media is a big thing. There was lots of comments on social media. If family members have private social media accounts, is that public dissemination?
Does it matter that the state conceded that a Facebook post would be covered by this order?
The state in its briefing suggested so. I'm not sure I agree with that. I think that that may not be public dissemination. I've been asked these questions and I can't give the answer any more clearly than anybody else from reading that order. I want to point out to the court that we do dispute the extent of the media coverage, the undisputed nature. Everything is in dispute here. Yes, there was media coverage. I don't think it was near as extensive as I've seen in many other cases, but we don't know because the court didn't take any evidence, so there's no basis.
I think there was media coverage in this particular area. Judge Elmore and what she did had a Streisand effect, that more people became aware of this case because of the judge's actions. And now this case does have more attention and eyes and media all across the US and possibly the world because of her trying to silence everybody when it could have just been localized and we wouldn't even know about it. It would have just been there. There would have been coverage there, which that's where they're seating a jury. But the case blew up because of the nonsense that was happening in it. And someone's rights were being trampled on, and we just cannot stand for that.
For that statement. There's no basis for the statement that our written statement was the cause for the gag order. Nobody even alleged that in the motion. Nobody found that in the order. So I don't think that that's a fact that the court can rely on. I also want to suggest to the court as to the standard. And by the way, there's no evidence of risk to witnesses. No one has even raised that. That was commented on a moment ago. I don't know where that came from. There's been no allegation of that, no indication of that. But as to the standard, I do not deny that Gentile may provide some general baseline test for trial participants, but it cannot be the only expression of a test because of the limitations that we've discussed previously as to the regulatory nature and the lack of prior restraint. I think the court has to consider the heavy weight of the First Amendment rights that are at issue and honor those. And here, Aaron Spencer's not asking for a gag order. It's his Sixth Amendment right to a fair trial. And that is usually raised by the defendant in cases where the defendant attacks a gag order. We are not doing that here. So there's not a Sixth Amendment right as competing with a First Amendment right, as is discussed. I think Nebraska Press talks about how the founders didn't tell us which one should win the day. But that's not the issue here. The public has a right to a fair trial, sure, but they also have a right to hear my client's speech and to know what's going on in their judicial system. Thank you.
Good close of last statement. Okay. So that was the hearing. And obviously they don't issue a ruling from the bench. That ruling did come out. Like I said, I will put that in the description box so that you have that and you can go review it as well so that you have substance to this hearing if you haven't seen it before. But that's going to be it for us today. And we will continue following this case. The trial is coming up. And will Aaron Spencer have justice? Will Aaron Spencer's daughter receive some sort of justice? Because her justice against her, the predator that went after her, is no longer here. And he didn't face, I guess he did face consequences, but not in the courts. So let me know your thoughts down below, and I will see you in the next one. Bye, guys.